not going to give a comprehensive account of the law of forum non-convenience. It's far too warm, and also would take days to do that. And also, there are lots of you that know a lot about it, and some real experts, so it's not necessary to do that. But what I will do is just go back to the fundamentals for a moment. And if anything, that will be useful in setting up the case study that Will's going to embark on later. Forum non-conveniens at its root is as a doctrine whereby an English court may exercise a power to decline jurisdiction, effectively to turn away a case that it might otherwise hear in favour of a better placed foreign court. And it really became part of our law as a result of two House of Lords cases in the 1980s. There was a power to do it before that, but it was a much narrower one. That's about 100 years of legal history in about 30 seconds. People have written books about that, so you know, be grateful. I've summarised it that briefly. Next slide, please. The leading case, though, is still the 1987 House of Lords decision, Spiliada, probably, possibly, maybe the most cited case of all time, and that hasn't changed. And so, in essence, the basic principle, as Lord Gough put it, English proceedings may be stayed, and the case turned away, essentially, if there's some other available forum having competent jurisdiction, which is the appropriate forum for the trial of the action. Put another way, in which the case may be tried more suitably for the interests of all the parties at the ends of justice. So, no, I don't need to do it yet. I didn't look at you to change the slide just because you're taking a picture. And it was quite funny. So that's the definition. Really importantly, built into the definition, there's a margin. In other words, the alternative forum must be clearly or distinctly more appropriate than England and Wales, if not no stay. So, and that margin is features in the case study that Will's going to take you to later in Clarke, so we'll come back to that. And obviously the burden of proof varies if it's a service in case. So if you're a defendant and you've been served in the jurisdiction in England and Wales, then the burden's on you as a defendant to show that there's some other available forum. And if it's a service out case, if you're a claimant serving on a defendant abroad, then the burden's on you to show that England or Wales is the clearly the more appropriate forum. Next slide, please. So it's a very broad definition, and it gives the parties lots of scope to you could say, simply to generate issues. Certainly, there's lots of potential to generate issues with it, and that's really underpinned by the court's insistence that although it's called forum non-conveniens, it isn't just about convenience. It's about appropriateness. So factors to do with convenience, like where do the witnesses live, where are they based, and the experts based, and so on, are essential parts of it. But also matters to do that relate to the appropriateness. In other words, where, stepping back from the case and looking at it around, where should it be, where ought it to be heard. So it's a very broad definition. Takes lots of factors into account. As Lord Templeman put it in Spiliada, the factors are legion. Sometimes the test is expressed in terms of where is the centre of gravity of the dispute, as if the litigation were like a sort of spinning top, just sort of waiting to find where it needs to rest. Thank you. And once you've got through all of that, as if that weren't enough to wrap your head around, you then have to grapple with what's sometimes called the second limb. So this arises in a situation where, yes, there is, on the face of it, a clearly more appropriate forum somewhere else than England and Wales, but there's still a sort of extra time, if you like, at the end of the 90 minutes. If the claimant can prove that there are circumstances by reason of which justice requires that shouldn't be a stay, then the case might still end up being litigated in England. What does that mean in practice? Well, encompasses lots of different things, but it encompasses cases where the claimant just won't get a fair hearing abroad. Some of the most sort of colourful cases aren't really from personal injury at all, but The recent case of Qatar Airways, the claimants were Qatari, and they said if they litigated in the UAE, all the courts would be biased against them. They might be put in prison, possibly even tortured. So it takes in that kind of really extreme example, but it also takes in much subtler, more systemic things like, well, they're just not used to litigating this kind of thing in that other jurisdiction, or it might take a really long time to litigate there. Okay, so that's the structure of the rule. Thank you. And you can see there's a real advantage in having such a broad rule that takes in so many different factors, in that it's fact specific and very sensitive to the individual case. But on the other hand, the disadvantage is sometimes difficult to predict the outcome and can be very involved and extremely hard fought. It's supposed to be a summary procedure. It's very rare for there to be oral evidence of any kind, as there was, as confirmed recently in BB and others. Not unheard of. I think in Pike Indian hotels there was oral evidence from expert witnesses, but generally speaking, no oral evidence. And as I say, it's supposed to be summary. Now, if you were to ask the app spelled SIRI, I'm not going to say that because otherwise I might summon her, or at least or several of her. But if you were to ask her to show you a collection of really hacked off judges, she could do worse than showing you pictures of pretty much every judge in a reported case who's dealt with forum non-convenience, because they always complain, sometimes bitterly, that it has been over litigated and has taken far too long, cost far too much, and it's supposed to be a summary procedure that's done in hours, and yet we've spent days litigating it, and might have even gone on appeal once or twice. I think, they're right in that it is self-defeating if you actually end up spending more time litigating jurisdiction than you do the trial, and that's absolutely right. But is that likely to change? Probably not, because there's so much at stake in jurisdiction applications a lot of the time. And the rule allows for such a broad scope of range of factors to be taken into account. It's understandable that lawyers doing the best by their clients are going to introduce lots of evidence, and indeed expert evidence in most cases. So I think in terms of what next for forum non-convenience, I think that gripe by judges is one of the things that's probably not going to change. Next. Okay, so it's a much analysed and written about doctrine, very controversial, and often discussed in terms of how it should be reformed and so on. So really, what I'm going to do just over the next few minutes, just pick out some of the key trends for non-convenience as I see them. I think it's impossible to be too confident or comprehensive about this, but it's just the way I analyse it. So the first point is far greater prominence and a much broader scope of application than it ever had before. And this is a process that's already at least a year underway. So as a result, obviously, forum non-convenience applied in all the cases where the defendant was non-EU domiciled before. It's not a new phenomenon or a new thing to cross-border PI lawyers, but of course, as a result of effectively the hard Brexit that we had with regard to jurisdiction and judgments and the falling out of the Brussels regime, it now applies across the board pretty much, and it takes a really central importance, and it applies to, excuse me, my badge, applies to cases where it never did before, in other words, where the defendant's EU domicile. There are some important, significant carve-outs from that, obviously. If it's an accident in the course of carriage by air or sea, in other words, under Montreal or Athens, then there's no forum non-convenience arguments in those types of cases. Consumer contract cases, there's a legislative carve-out for that. So package travel, unlikely to be touched by it, and also employment contract cases as well. So those are quite significant carve-outs, but nevertheless, it's got a really big and sort of, well, far bigger scope of application than it did before. Next, please. So the next sort of what next point relates to the sort of knock-on effect that has on how cross-border PI cases are to be litigated. When in cases where the defendant was EU domiciled, which probably the majority of cases that cross-border PI lawyers would have dealt with before, jurisdiction was uncontroversial because it was as of right. Key examples being you could always sue the defendant where they were domiciled, and then in an Odenbright claim could always sue in their jurisdiction of domicile. Many of those cases now are going to be subject to the discretion. Jurisdiction will be a live issue in far more cases, and not just a live issue. Many really clear-cut cases, where there'll be no argument really, are now on either way cases essentially. So in that kind of middle ground of a little bit difficult to predict how they might go. And a really good example is the case that Will's going to talk about shortly, which in Clarke, where if it had been possible to issue the claim only a matter of 2 or 3 weeks earlier, would have been under the Brussels rules, and there wouldn't have been any argument about jurisdiction at all. But as it turned out, there was a very involved argument, and it was a very close run thing. I'll let him tell you what the actual outcome was. It's almost sort of inherent in a lot of cross-border PI cases that there's going to be reasonably finely balanced arguments on forum, because if you have an English or Welsh domiciled claimant significantly injured in an accident abroad, say in the EU, where liability is an issue, you can immediately see there are significant factors pointing to the EU country, because that's where it happened, that's where liability is to be determined, but also to England and Wales. That's where the claimant lives, that's where they're going to be suffering their injury, that's where they're going to be cared for. So it's almost sort of inherent that there's going to be a penumbra of doubt in a great many cases going forwards. And that has another knock-on effect, which is there's already a sort of front-loading of work, which the pre-action protocol, cost budgeting, and so on compels. But this compels it even further, because if you think you're likely to be facing an argument on a forum on convenience, then it repays you to investigate the position as regards what the foreign law is, what the foreign procedure is, what the value of the claim is, what enforcement is likely to be like in the other jurisdiction. It forces you to grapple with and evidence all of those things early in the litigation, perhaps earlier than you might have done otherwise. Next slide, please. So the next, what next? This is really a comment on the shift in emphasis in how forum non-convenience is likely to be applied in the future. When Spiliada was decided, it's not quite true to say the internet hadn't been invented, because I think strictly it was invented in 1983, but nobody really knew anything about it. And I think if you'd said to Lord Gough and the other law lords in 1987 that in the future you'd be able to exchange thousands of pages of disclosure at the touch of a button over thousands of miles at very low cost, witnesses would be able to give evidence remotely from the other side of the world, again, at practically no cost, almost as if they were in a room with you. Well, it might not have blown their minds, but I think they thought it was the stuff of science fiction. And also a much greater emphasis in the past was placed on presence of witnesses in court, their demeanour and so on, which I think is something which is really declining now. There was already quite a big move before the pandemic towards recognising that what had been key factors in the past, in other words, availability of witnesses, where the witnesses lived, where the physical documents were, those things were declining in importance. And the pandemic's really accelerated that, because it's shown us in many ways what was possible. And it's now not remarkable that a long commercial court trial should be done remotely, or a PI trial or a family court trial should be done remotely, whereas it would have been in the past. And the pandemic's really given a sort of boost to that. So what does that mean for the application of forum non-convenience in the future? It means that it doesn't mean that convenience in terms of where witnesses live and so on is irrelevant. I mean, there are obviously, especially in personal injury cases, going to be cases where that's still important. But it does mean, as a general rule, those previously key factors are now of much less significance than they were, and probably as a result, factors like what's the appropriate forum, where should this case be litigated, is now correspondingly more important. Next slide, please. The next, what next is, yes, well, I think that I sort of headed this, criticism of EU 27 courts. So we saw earlier, one of the possible arguments that a claimant could make is that they're not going to get, or there's a risk that they might not get substantial justice in the court in the other jurisdiction. That can be raised under the so-called the second limb. It could also feature as one of the factors under the first limb as well. So you can deploy the same argument at different stages. Never before, while the UK was a member of the EU and the Brussels regime was in place, was it ever possible to make criticism of the EU 27 courts along the lines that they might not be suitable for to hear a personal injury trial, or you might not get, there's a risk you might not get substantial justice if your trial went ahead in the other in that jurisdiction. It wasn't possible because the Brussels regime didn't allow for that kind of argument to be made, and also it was, you could say, pretty much unthinkable as well, because we were all the UK, I should say, was part of an economic union, had signed up to or had imposed on it, you might say, a regulation whereby there was mutual recognition of judgments. But now that argument is open. Those kind of arguments are open to claimants to make. It's unlikely, very unlikely, that you're going to be in the kind of territory that the claimants were in Cherney, Abramovich, Altimo, or Qatar Airways. Those are all quite well-known commercial cases where parties were saying, I won't get substantial justice in Ukraine, Russia, or the UAE, or because, you know, the court system there isn't impartial. You're not in that kind of territory, but you are possibly. There may well be arguments, subtler arguments, about delay, inexperience of judiciary in dealing with certain types of case, for example, serious brain injury, or involving incapacitous claimants or group actions. There might not be adequate or any real provision for interim payments to be determined and paid out for seriously injured claimants. All of those types of arguments, which were completely shut off before, are now open potentially to claimants to make, and that's not a particularly comfortable position, because it's not something that we've really been used to doing before. But it seems to me there will be cases where that's something that has to be at least looked into, and it will be in the client's interest to make arguments of that type. And finally, on the what next, reform. I think it's probably fair to say there's been a recognition since Brexit that there were some advantages to the predictable rules-based regime for jurisdiction, which we were signed up to before. I think in some quarters that was a rather belated recognition. Obviously, the UK government has gone all guns for the UK to accede to the Lugano Convention. That's been rebuffed. And I think for the moment, we just have to regard that as that's where it lies for now. But there are some other steps that have been taken, some of them before Brexit Day and some shortly after Brexit Day, which really are designed to carve out particular cases from forum non-convenience, so you don't get these types of arguments being made. I'm thinking particularly of CPR rule 6.33. So that's the the rule of the CPR that carves out consumer and employment contract cases from forum on convenience, and jurisdiction agreements as well. So there's been a sort of a move to make sort of carve-outs. What's going to happen? What's going to happen next? Well, something's going to happen, I think, in this regard, because changes to the gateways and to jurisdiction rules post-Brexit are, we know, being actively considered by the Rules Committee. The sexily named Rules Committee subcommittee determined. We know what this, because the minutes are publicly available, and there may be other people here who've actually read through the minutes. Besides that, I really hope there are, because I'm going to feel really very sad if I'm the only person here who's read these minutes. They decided in November last year that they were going to undertake a project to look at this kind of thing. And they were going to do it in conjunction with the Lord Chancellor's Advisory Committee on Private International Law, which is chaired by Lord Mance. So what they said initially was, we've had a meeting, and then we're going to have another meeting in the early part of 2022, which they have. And they have made a little bit of progress. It's sort of quite comforting to look at all these very high-powered people and judges having sort of slightly inconclusive meetings like all the rest of us do. But essentially what they said is they're not going to do a sort of root and branch reform, but they are they're not going to look at the broader issues of jurisdiction, but they are, it looks like, in the market for tinkering with Practice Direction 6B and the gateways again. And there's going to be a consultation in the spring, which you would think means very soon. And there's going to be a fuller report in May. And in a wonderful bit of sort of corporate speak, they round it off with: the aim is that the amendments are incorporated into the next mainstream update as part of the October 22 in-force cycle. So I think the answer is we don't know what that's going to yield, but I think the probability is that there's going to be some more tinkering along the lines of what they've already done last year. And what they did last year was they took exclusive jurisdiction agreements out of the sort of scope of forum non-convenience and said effectively that skips forum non-convenience jurisdiction automatically. And I think it's quite likely they'll do a similar thing with other types of case. Exactly what types of case we don't know, but we'll just have to see. Watch this space. William.
Thanks, Dan. I'm going to talk a little bit about well, first of all, I'm going to see if the clicker works. Okay, never mind. I'm going to talk a little bit about the case of Clarke, which is a judgment that came out end of February, so it's quite recent, and it's a useful example of a real life treatment of an application for forum non-conveniens involving another EU jurisdiction, in this case France. And it gives, I don't think it sets out any particularly new principles or anything like that, but it's a helpful practical steer as to how these applications might work in practice. So the facts of the case are set out on the slide. It's a skiing accident in Courchevel, France, in January 2018, in which the claimant was domiciled in France, but the first defendant, who was the English skier who crashed into her, was resident in England, and the insurer was also domiciled in England. And the accident, I mean, importantly for the FNC issue, the accident was admitted to be the sole fault of the first defendant. So there's no issue as to liability. And the claimant brought a claim against the defendant in the English High Court. If we have next slide, please, Vicky, thank you. French law applied. The claim was pleaded at around 150 to 200,000, and the schedule of loss had broken that down and set out how it was calculated in terms of applying French law on damages. Crucially, the claim was issued on the 14th of January 2021, so after Brexit exit day, notwithstanding the fact that there had been a letter of claim sent as far back as April 2018. And the defendant, having not said anything about the appropriate forum up until this point, applied for the claim to be stayed on the grounds of forum non-conveniens, and there was a hearing before Master Dagnall in November 2021, with judgment being given at the end of February. Next slide, please, Vicky. Thank you very much. And it's important to note, obviously, that French law applied. The judgment in Clarke goes into some detail, quoting at length from Wall and Mutual de Poitiers, setting out the fact that the quantification of damages will be governed by French law, but the English and Welsh rules concerning how that expert evidence was to be adduced would be applied, with the consequence that the cost recovery would be as per the English law. And it's also important that what is referred to in the judgment, and hence potentially important, that the outcome in damages might still be different in the English court, even if both courts were applying the same law in theory. So next slide, please, Vicky. Thank you. So what I've done is pulled out the factors from the judgment, some pointing towards a stay of the English claim and some pointing against it. Dan's already taken us through the legal principles, so I'm not going to go over those again, but essentially it's a two-stage analysis. Firstly, deciding whether there is a clearly more appropriate forum, and then, even if there is, going on to consider whether there's a reason why a stay shouldn't be given. And in the judgment, the factors are not grouped this way, in some pointing towards a stay and some against. They're just considered on a per factor, one by one basis. You can go and look at the judgment for more detail, and if you do so, you will see that Master Dagnall, I have identified him as a kindred spirit to myself for his use, his seeming love of brackets, and indeed brackets within brackets, which you will see as a vice that I share even from these slides, so I apologize for that. So there are a number of factors pointing in either direction. So those pointing towards stay. Now, we heard earlier that, indeed from Karen's talk, that the location of the commission of the tort is the starting point. And as is emphasized in the cases and was referred to by Karen earlier, that it is only a starting point and it's not a presumption, but it is a potentially weighty factor. In this case, of course, because liability was admitted, it had very much less weight than it would otherwise do, because there was no argument about the liability or contributory negligence or anything like that. So essentially it was an assessment of quantum, and hence the location where the accident happened had less weight than it would do otherwise, although of course lots of the losses, or indeed all of the losses, were suffered in France, which was a factor pointing pointing towards France having the closer connection, and hence there being a stay of the English claim. And similarly, French law applied, and therefore the French court wouldn't need expert evidence, whereas the English court would do, although again, and this I suppose goes back to my brackets point, in the judgment, Master Dagnall does, he refers to a point pointing in a particular direction, but then says, well, actually, maybe it doesn't quite point all the way in that direction because of X, Y, and Z. So there's a lot of balancing going on for each of the factors, and there are sub-factors within the factors, some of which point in a different direction to the main thrust of the factor. So there's a lot of nuance, I think, going on in most of these. Vicky, next slide, please. Still on factors pointing towards a stay, i.e. factors suggesting that there's a closer connection to France, the claimant herself was French, and here's an example of a caveat. She's French, but she's able to travel to England and give evidence in English, so that's not quite as clear-cut as it might be otherwise. The claimant's medical experts were French and would have required interpreters. And again, a factor that still points toward France. The claimant would need to instruct an accountancy expert, but again, she'd tried to reduce the effect of that by saying that she would instruct an expert who could give evidence in English, therefore hoping to reduce the extent to which that pointed towards France being the appropriate forum. So next slide, please. Thank you, Vicky. So on the other hand, there are a number of factors pointing to the fact that France was not a clearly more appropriate forum than England. I've already mentioned the fact that the claimant herself was able to give evidence in English and indeed to travel to England. She indicated, in fact, by way of an email after the hearing, that she didn't intend to call any further factual witnesses. So it was just her evidence. in terms of factual evidence. And Karen referred to this earlier, actually, that it's not even as simple as saying, well, if the claim is heard in France, then the claimant is based in France, and therefore that is a convenience factor that points in favour of it, because the trial would have been heard in Abbeville, which was both geographically, in terms of as the crow flies, further from where the claimant was based in Orleans, and it would also take longer for her to get there. Similarly, the claimant's French lawyer, who she'd instructed, wouldn't be able to represent her at the trial in Abbeville because they weren't qualified there. And therefore, although on the face of it, some of these factors, which might look as if they point quite clearly towards France as being the more appropriate venue, when you analyse them in a bit more detail, turned out not to be quite so emphatic. Thank you very much. I suppose the first bullet point technically is a caveat to a factor pointing the other way, but what Master Dagnall said is that actually, although there is going to have to be medical evidence, and of course the claimant's medical experts were French, it's not clear that how much of a dispute there would be, because the defendant hadn't actually challenged any of her medical evidence, despite having had the letter of claim and the medical evidence for quite some time before the claim was served, although the Master did assume that there would be at least some dispute. And possibly the key factor is that, of course, the defendant and the insurer were located in England, as were their solicitors who've been dealing with the case, and crucially, that enforcement of an English judgment against the defendants would be straightforward, given that they were based in England, whereas enforcement of a French judgment would require an application under the 1933 Act, which could potentially incur costs and delay. A point raised by the defendants was that under French law, there was a potential for a later claim for subsequent deterioration if it turned out that the claimant didn't recover as expected, and that was a procedure that was specific to French law. The English courts didn't really know how to deal with that, and therefore it was a factor that pointed strongly towards France being clearly the more appropriate forum. The way that the claimant dealt with that was to say, well, we don't know whether that's going to happen. So effectively, you just ignore that, treat it as an entirely separate set of proceedings. If it arises, it arises later, but it doesn't come into the analysis now. And the Master effectively accepted that. So Vicky, next slide, please. So the conclusion on the first stage was that although there was a degree of force to the defendant's submissions, and in fact, if the question had been simply which is the more appropriate forum, then Master Dagnall may well, and in fact said he would suspect that he would have found that it was France, but the test isn't simply which is the more appropriate forum, it's that the defendant has to show that there's an alternative forum that is distinctly or clearly the more appropriate one compared to England, and therefore the test was not met primarily because of the English location of the defendant and the automatic right to enforcement of an English judgment against them. Master Dagnall also said that essentially the assessment of quantum under French law ought to be fairly formulaic and something that English courts are used to doing post-war, and therefore not a reason for the English court not to be an appropriate forum. Thank you. So technically speaking, that was the end of the argument, because if you don't, as a defendant making a forum non-convenience application, if you don't get over the first hurdle, then the court doesn't need to consider the second one. But he went on to consider it anyway, and he said that even if he had been persuaded that France was clearly the more appropriate forum, he would have declined to enter a stay on the basis of the second stage, i.e. achieving the ends of justice. And the judgment is potentially slightly unclear in the sense that there's a little bit of bleeding between the two stages of the analysis, because some of these factors are clearly appropriate, let's say, to the second stage, but also potentially appropriate to the first stage. So the issue of enforcement of the judgment, for example, that clearly is a judicial advantage to the claimant, which comes into the balance at the second stage, but it's potentially a factor that goes to whether or not England is the more appropriate forum as well. But in terms of the analysis of the second stage, in this case, yes, please, Vicky, next slide, thanks. It was clearly a factor that up until 14 days prior to the issue of the claimant could have issued the claim in England and Wales as of right with no possibility of a forum non-conveniens challenge, because prior to EU exit day, it's clear from the case of Owusu that forum non-conveniens couldn't be raised as an objection under the Brussels regulation. And even though Master Dagnall said, well, quoting the Bethel and Deloitte case, there's no obligation on the part of the defendant to point out any errors on the part of a claimant, he did still find that there was something tactical about the way the defendant had approached it. What the defendant said is, well, we're simply going by the law as it is at any particular given time. We couldn't raise this issue before exit day. Now we can, so we are doing so. I think the Master found it slightly unattractive and opportunistic of the defendant to have not made any mention of this issue previously, not taken any point about the claimant's medical evidence or anything like that, and then to have taken the point when the claim was issued after 31st of December 2020. And that was something that weighed in the balance in the second stage. Vicky, can we go to the next slide, please? Thanks. And I've already mentioned that the enforcement is a factor that potentially goes to the first stage, but it definitely goes to the second stage. And Master Dagnall found that it was a legitimate procedural or judicial advantage to the claimant. There's a little bit of confusion, I think, between some of the paragraphs of the judgment as to the labelling of this factor. It's clear that it's a factor that points against granting a stay. It's not totally clear in the analysis how Master Dagnall has categorised it and where it fits. And then it's been said repeatedly today that conveniens in forum non-conveniens doesn't just mean convenience, but convenience is not irrelevant. And London was more convenient to the claimant and also to the defendant. I think that, just going back to the point about the defendant taking a tactical stance, one of the strange features about this case is that the defendant was English and based in England and arguing for the France to be the more appropriate forum. So it's not as if it was one of the usual cases where where the convenience factor is at least a partial explanation for why the defendant is arguing what they're arguing, because on the face of it, it's much less convenient for the defendant to have to defend the claim in France. And I think there was a suspicion that it was really all about the cost recovery, and that what the defendant didn't want to do was to have to pay English costs. So if we get the next slide, thank you. So I think there are a few points to take away from this. I mean, obviously, every case is very fact specific, and there are certain features of this case that are particularly unusual, and hence from which one would have to be cautious before drawing too many conclusions. In particular, the facts are the wrong way around. They are set up in an unusual way, in the sense that it's an English defendant seeking a stay of the English proceedings. The enforcement point will often be the other way round. And of course, the other key point or unusual point about this is that it's a transitional case, because the point about costs being wasted, and just to go back to that point for a second, one of the things that I think made Master Dagnall think that the fact that the claim had been going on under the English pre-action protocol for a number of years without any issue or any challenge, the reason that was a relevant factor is that the claimant had been following the procedure that's laid out under the English procedural rules, hadn't done anything wrong. But if the case had to be heard in France, then most or all of those costs would have ended up being thrown away, and that, I think, added a lot of weight to the argument that it was a jurisdictional advantage that the claimant would lose if the stay was granted. Now, that's going to be a factor in a decreasing number of cases, obviously, because as we get further and further away from Brexit exit day, there are going to be fewer cases that occurred prior to it, and in which that will be a relevant factor. The other point is that liability not being in dispute in this case was, I think, a very crucial point. I I recognise that the authorities say it's only a starting point, but it's clearly a much easier argument for a defendant to make if they can say, well, the accident happened in France, it's governed by French law, that is clearly a factor that ties the claim more closely to France, or to use the analogy Dan quoted earlier, puts the centre of gravity of the claim more easily and more readily in France. Next slide, please, Vicky, thank you. And just a few other points to take away. I would entirely endorse the point that Karen made earlier about detail. I've done a bit of a whistle-stop tour through the case, but if you go and look at the judgment, there's a huge amount of detail, and it shows, I think, not just that you have to that it really repays a detailed analysis of all of the aspects of the case to see which way the factors point, but also many factors will point one way in terms of their headline valence, but there will be counter arguments you can make against them that perhaps take away some of that weight. For example, the claimant needed extra accountancy evidence, and that was going to be in France from a French expert. That would point towards France, but she was able to give an indication to the court that she would instruct an expert who could give evidence in English, and that lessened the weight of that factor. So detail matters. There's a lot of nuance. There are things that parties can do to affect how much weight the factors have, and you can try and strengthen your case by doing those. And then finally, just to bear in mind the practical evidential considerations. Obviously, very full witness statements in this case have been filed by both parties, covering most of the points. But even so, there were some lacunae in the evidence, and some things which were only addressed by emails from counsel after the hearing. And so I suppose the point is, if you want to invite the court to make findings of fact in your favour that support your argument either for or against the stay, then you need to think in as much detail as you can about what needs to go in the witness statement, because there isn't going to be oral evidence generally. And if you want the court to make a finding in your favour, you need to have the evidence in order to do that, because there are points in the judgment where Master Dagmel says, either I can't make a finding about this because there's no evidence, for example, how long it would take for a case to come to trial in France, or where one party had evidence and the other didn't have any evidence to contradict it. So Master said, well, I'm compelled to find in favour of the party that has evidence on it. So I think that's a very important point to bear in mind. And I think I'm just about in line with Gerard's indication that I should stop now.